Let's have some calming breaths. Focus on the water before we move on to NRA RT. NRA RT, you can remember this one because RT stands for really terrible for parents. No showing of parental blame is required before a juvenile court may assert dependency jurisdiction over a child at substantial risk of physical harm and illness, even when the parent has tried everything possible. So, if you've read NRA Precious D, you will see that the facts of NRA RT are pretty similar in terms of an out-of-control teen and a parent who is trying to do everything they can. When RT was 14, she began running away, stopped attending school, making false abuse claims, and having children. The mother sort of tried to do everything she could. She called the police. She sent RT to reside with the grandparents. She unfortunately made the mistake, in my opinion, of calling the Department of Children and Family Services to help her. Because of course they turned around and filed a petition against her under B. The trial attorney, of course, made a Precious D argument, and the court sustained the allegation under B because, quoting the court, Judge Downing in Department 407, mother can't control her, so she's given her off to grandparents who can't control her either. But then the court placed her with the grandparents, sustaining the petition, and mother appealed. I will tell you, I have read this opinion no less than 10 times, and I'm still not sure I can explain it to you. There's a lot of arguments about, in the opinion itself, about the Constitution, about the function of dependency court versus delinquency court. This division disagreed with Precious D, and I think, if I'm understanding their reasoning, which I'm certainly not sure I do, is because if you look at all the other subdivisions under Section 300, they all say something about the parent's abuse or neglect. So when we have F, the parent's abuse or neglect caused the death of a child. When you have an A, the parent's intentional infliction of serious physical harm. So the Court of Appeal said, well, B doesn't have that language. So therefore, there must be no showing of parental unfitness to sustain a B count. I don't have a good answer for this. What is important for you guys to remember is that right now, Precious D remains good law. Okay, this did not overrule Precious D. This is one division of the Second Appellate District disagreeing with another division of the Second Appellate District. They don't have the authority to overrule one another, so there's a split. So the best you could do in a case like this is to have Precious D and RT next to you and try and, figure out how you can put more of your weight on NRA Precious D depending on the facts of your case. The other thing about RT is that the Court of Appeal, for some really odd reasons, says that this opinion is consistent with Section 300.2, which I totally disagree with. Section 300.2 is the section of the law that sets forth the purpose of dependency, which is basically to protect abused and neglected kids. So I don't think RT has anything to do with that. If you're going to say these kids don't have to be abused or neglected, they can come into dependency court and we'll save them anyway. So there's clear problems. The appellate attorney for the mother and NRA RT has filed a petition for review with the Supreme Court. There is a chance that even if the Supreme Court does not grant review because of the split between Precious D and RT, that they may depublish this decision. So whatever God you believe in, whatever candles you light, whatever chants you do, dances, make it focus towards NRA RT. Okay. So we're going to move out of jurisdiction, excuse me, and now we're going to move on to noncustodial parents. If you remember the training from, I think, early last year that Steve and Danielle did, we had a whole host of cases on 361.2, and that hasn't really changed. It's still a pretty hot issue for the Court of Appeal. The first one is NRA Maya L. It was a case that came out late last year. At the 6-month review hearing, the juvenile court need only determine whether court supervision is still necessary when a child is placed with a non-custodial parent. So I think our courts, and I will say some of my attorneys, and I'm sure it's the way across the building, still are having difficulty understanding if we place a parent with, place a child with a parent under 361.2, is it a 364? Is it a 3.6? It's sort of all over the place. In this case, Maya was declared dependent. She was removed from mom and placed with her non-custodial father under 361.2, but mom was given FR. So at the 364 review hearing, the mother said, well, you should consider whether or not return to me is detrimental. So use a 21E standard. The court said, no, I don't have to get there. I'm at a 364 and terminated jurisdiction with the custody order to father. I believe this was Loznick in 403. The Court of Appeal affirmed, basically, the court said when the child is placed with the non-custodial parent, they need only consider whether supervision is still necessary, but 364 principles do not apply. This is a very confusing opinion. It's not me trying to be confusing. They basically said the court should have looked to 36621E, which provides, and there's specific language in 21E, and honestly, it wasn't until I read this opinion, I don't know when they stuck that in there. But there is specific language addressing kids that are placed with a non-custodial parent under 361.2 in those review statutes now. They sort of snuck that in there. Because now if you look at the language of 21E, it does say, probably at the very bottom, if the child has been placed with a previously non-custodial parent under 361.2, but with court supervision, then the court should still determine whether court supervision is necessary. So the Court of Appeal rationalized, well, even though the court said it was making the findings under 364, it really was following 21E, so it's harmless error. And when you look at 361.2 itself, it's 361.2B3. The statute says if services are ordered to both parents, so you have a 361.2 father who gets the child and they both get services, then review hearings are to proceed pursuant to section 366. That's what 361.2 says, and this is very confusing for our judges and for the Court of Appeal, but now I think they've tried to fix it by sneakily sticking this language into the review statutes to deal with non-custodial parents. So the moral of NRA Maya L is, if you have that mom, you may want to check your review statutes too, so that you can sort of educate the court on what standards should be used, because I do know a lot of our courts still say we're just at a 364, we're just looking at whether or not jurisdiction is still necessary. NRA CM is a great case if you have a non-custodial parent, not so great if you have a custodial parent who doesn't want the child to go with the non-custodial parent. But they do a great analysis under 361.2. The mom got in a big old fight with maternal relatives and she was arrested. The child was detained. The non-custodial father appeared and requested release, but the court said, well, I don't have enough information to release to you, which I hate, but okay. The children's attorney was absolutely opposed to the release of this 11-year-old to her father. The father, for his part, claimed that the mother and the maternal relatives had alienated him from his daughter. The court agreed with minors' counsel, found it detrimental to place with the father in a home where she had never lived. But I'll give you unmonitored visitation. The trial court in this case did not say I'm making a detriment finding under 361.2, which is sort of part of the Court of Appeals analysis. The Court of Appeal, though, reversed, basically saying, look, the kid's wishes, the sibling bonds, and the child's relationship can be considered. Father's old conviction for DV and mom's report that he was an alcoholic don't prove detriment because the department didn't file anything on this guy. And the child's desire to remain with maternal grandparents nor the alleged lack of an established relationship were sufficient to constitute clear and convincing evidence of detriment. So if you have a 361.2 case coming up, you absolutely want to read NRACM because they go through a very detailed analysis. And this was, I think, on the facts that we get, this was a pretty bad case for dad in terms of the facts, that they hadn't lived together, that He had been alienated, but the Court of Appeals still found in his favor. So you may have facts that are far less than what were there in Ray CM. All right, relative placement. We have another NRA RT, but not hopefully as divisive. Reversal required where the agency and juvenile court ignored the statutory mandate to consider relatives in determining placement. This was out of Alameda County, but I included it because sometimes things just surprise me. I don't know why. But this case stands for everything an agency should not do when it comes to relative placement. The parents immediately upon detention identified the paternal aunts, but the court said relative placements do not receive preference. Parents then tried to relinquish to a paternal aunt, which the agency denied, saying, well, we'll take a relinquishment, but only if it's to the foster parents, because we like them better. The court made the foster parent a NERFM to try and get around this. Juvenile court said, well, if the agency won't take your relinquishment denial, I can't do anything about it, and terminated parental rights. Court of Appeal reversed, holding no. This case in particular has a lot of good language on relative placement and relinquishment. We get a lot of questions about relinquishment. Parents want to relinquish. They want to relinquish to someone specific. They want to know the process. NRA RT has excellent language and sort of a guideline on what should happen if the parents want to do a relinquishment. I do hope you all know that relative placements do receive preference until a certain point in the proceedings, and that the agency cannot decide for the parents who they can relinquish to, and foster parents do not automatically qualify as NERFMs. See, this case makes you happy you practice in LA, right? Because don't go to Alameda County. All right, exit orders. There were a few cases on exit orders. The juvenile court lacked authority to condition the modification of an exit order upon father's completion of programs and counseling. This is an important one because I do see a lot of the courts doing this. Basically, the court sustained the allegation that father allowed an unrelated adult and current drug abuser to reside in the home. Father also tested positive for meth. This is a weird factual case. Father reported the child was missing. Police found him with Amber, who he said, that's my babysitter. Amber was extremely high when they found the kid with her, and stated father was known to allow women released from jail to stay with them in exchange for sex and drugs. Police searched Amber's room, found meth and pipes. Court sustained the petition and closed the case, giving the parents joint legal custody, sole physical to mom. I believe mom was non-offending under this petition. In referring to the custody order, the court, and this was Marpet in 410, and in order to modify the court's orders, father will have to complete a full drug program with weekly testing, parenting program, and individual counseling. The Court of Appeal sustained the jurisdictional findings regarding Amber and the babysitter and the drugs, but reversed the dispositional orders as to the language of the custody order. The trial court didn't find father to be credible in his denial of drug use, and that his use of Amber as a babysitter was an isolated incident. That's for affirming the jurisdictional findings. But they found that that the court's conditioning of the modification order upon father's completion of programs violated 302 subdivision D, and that the juvenile court had zero authority to condition the family court's modification of the order upon father's completion of programs. I'm sorry, it was not Marpet. It was Vasquez, Vasquez was the trial judge. So I think I've heard rumors that they're going to be getting rid of some of the riders attached to the family law orders. Just be careful, because I have been in courtrooms where I have heard the bench say something like, father has discretion to make mom's visits unmonitored once she completes 10 drug tests. If you have father, don't put your client in that position, because I'm sure all of you have experienced petitions that come in because there was a family law order, mother had monitored visitation, and father decided she was doing great and gave her unmonitored visitation, and then it came back in because mom wasn't doing so great, as it turns out. So just be careful. This particular incident, the Court of Appeal didn't like that Vasquez basically said, this is how you get your kid back. This is how you get unmonitored visits, as you do these programs. And what the Court of Appeals is saying is that's not your decision. That's the family court's decision, and that's their right to sort of look at the evidence at that time. So you can't make, you know, that the family court's going to modify it based on the completion of program. It's a whole separate process.
Do we need to change how we're completing riders?
Talk to your bench. You have to talk to your bench. Yeah.
The trial court can still give recommendations.
Yes.
They just can't make it conditions.
Yes.
Yeah.
Right. They can still, because typical in a 361.2 closure, when you get a juvenile court custody, the court's not giving them a case plan for FR, even enhancement at that point. And so oftentimes, Jennifer's right, what you'll hear is they'll say, can you make recommendations? Now, whether or not they're gonna want that attached to the family law order, I don't know. This really is sort of puts a weird spin on procedurally how we do things in terms of family law orders. So at this point, my advice to you is do what your judge wants you to do. Because I don't have any authority to tell you otherwise. Yes.
I prepared an order just a couple of days ago where Zeidler said kids visits with dad in a therapeutic setting. However, to have any visits, he has to be weekly random drug testing. Otherwise, he gets no visits. That's not going to meet this standard up there. That's what it sounded like. He accepted it. We JT'd.
Okay, so this is my last blurb, because I also want you to know some of these other things that's been going on around the state. The father on NRAZS did not appeal from his TPR. He appealed from the order finalizing the children's adoption and tried to raise issues as to why he shouldn't have been TPR'd on. And as it turns out, you can't do that. Court of Appeals said you're too late. So if you don't file a notice of appeal as to the TPR, you can't do it later when the adoption is finalized. Eskimo families fall within the provisions of ICWA. I had no idea, but I do now pursuant to NRAHG.
Who knew?
I'm sure Ms. Anderson knew. I don't know. Also, an interesting fact from the Court of Appeal this year: legal guardianship can be terminated by a parent under Section 388. This was Fresno, and the court said the parent tried to file a petition under 388 to terminate the legal guardianship over a dependency, legal guardianship over her children, and the court said, I'm not convinced 388 is the proper vehicle. Otherwise, guardians would be fending off 388s all the time. Again, feel grateful you work in LA County. And so there's a great discussion in there as to why 388 is the appropriate vehicle for parents to terminate legal guardianships until the kids reach majority. All right, that's it, everybody.
Thank you very much. Thank you. As always.
I didn't want to call her.
I think it's Sherry giving him things, you know, kids like tested positive for cocaine.
Sorry. No, I'm in your way. Bring it back to court.
younger students.